Mr. Calhoun, we have read your brief, and you have 15 minutes to present your argument as to why you think the court made a mistake in ruling against you, or at least partially made a mistake. So do you want to come up to the podium? We are recording this, so it'll be on Facebook. So just please identify yourself and also keep your voice up. And I don't think this is relevant to your case, but we always tell everybody that appears in front of us not to mention any victims' names or any children's names. Okay? So you have 15 minutes. Just tell us whatever you want to. It's in the record.
All right. Good afternoon, judges, and may it please the court. My name is Homell Calhoun, and I am the pro se appellant in this matter. I'd like to start with my first assignment of error. In that assignment of error, I argue that the trial court failed to comply with Civil Rule 53, B3 by denying all of my objections except for one regarding the BMX bike and bike rack, because I did not comply with its April 3rd, 2023 order to get the compact disc audio recording of the trial. However, Civil Rule 53D3B3 only requires my getting the compact disc audio recording if I cannot get the trial court a transcript of the trial or an affidavit of the evidence if the transcript is not available. In Gill versus Grafton Correctional Institution, the 10th District concluded that a transcript is unavailable for purposes of Civil Rule 53D3B3 if a party is indigent and proves so through an affidavit of indigency. Since I filed an affidavit of indigency, and that affidavit is in the record, I complied with Civil Rule 53D3B3 when I filed my affidavit of the evidence with the trial court, and therefore the trial court's order to get the compact disc audio recording was not grounds to overrule my objections to the magistrate's decision, since the compact disc audio recording was superfluous. And that leads to my second assignment of error, judges. On April 3rd, 2023, the trial court ordered me to get the compact disc audio recording of the trial to it by April 24th, 2023. The problem with this order by the trial court is that the Akron Municipal Court was closed to the public from April 10th, 2023 to April 24th, 2023 because of the meeting of the grand jury in the Jalen Walker case and the protest that would follow in Akron. I also...
Mr. Calhoun, how much total time did you have to pay the $250 and get the CD to the court? How much total time did the court give you?
I want to say about a month and a half.
Okay, it's like 45 days, you think?
Yeah.
Okay, thank you.
I was also incarcerated for a short time during this period, so I couldn't personally go down to the Akron Municipal Court or call the court reporter to get this compact disc audio recording. I asked a friend to try to do it for me, but he couldn't get into the courthouse or get a hold of the court reporter, so I mailed out a motion to the trial court asking it to either obtain the compact disc audio recording of the trial itself, or in the alternative, give me an extension of time past April 24th, 2023 to get the CD, since the trial court was not going to reopen until the day the CD was due. The trial court, which received this motion for an extension of time and timestamped it on April 20th, 2023, never ruled on this motion, and then in his June 2nd, 2023 order denying my objection in part stated that he was doing so because I did not get him the CD for the trial. This was clearly error by the trial court, as he already had the affidavit of the evidence and an affidavit of indigency from me, which means he had what he needed to comply with Civil Rule 53D3B3. As for my third assignment of error, there were several things that both the magistrate and the trial court judge failed to rule on in their decisions and judgment entries. One, there was no mention of the Pontiac G8 or the $2,500 I paid for the Pontiac G8. Two, There is no mention of the $480 cash advance on the bounce refund check of $1,980 for the BMW that I purchased from the Balls. 3, there is no mention of the $400 I paid for the 2 keys for the BMW and Pontiac G8 that I purchased from the Balls. 4, there is no mention of the jump starter box that I purchased as parts to fix the BMW. The magistrate and trial court judge found that I only paid $1,306 for the BMW, but all of their findings of what were payments towards the BMW were actually payments towards the Pontiac G8. I paid the $1,500 for the BMW within a day of the purchase as stated in the handwritten contract by Mr. Ball and based on the text messages by Mr. Ball. It's clear I did not pay the $1,306 for the BMW because, as shown in the plaintiff's exhibit number 6, at trial, Mr. Ball texted me at 12:07 p.m. on March 20th stating, "It's Sunday, so probably going to be tomorrow before I can go to the bank and pay you. I may be able to give you like $1,500 today. My dude owes me $3,000 and said he will have half today." In those text messages in Plaintiff Exhibit 6, he then talks about getting a key for the BMW since he had lost the key to it. At 5:24 p.m. on the same day, Mr. Ball then states, "I may just go ahead and let you cash this check. I'm just going to make sure I can get to my money first before I'm effed still, because I can go to my people tomorrow and cash it at their drive-through if I need to." Clearly, I paid more than $1,360 for the BMW. If you look at the magistrate's decision and compare it to the trial court judge's judgment entry, they also forgot to mention the $100 I paid for the jump starter box under the materials that I purchased for Mr. Ball to fix the BMW. The Balls took that jump starter box when they towed the BMW away on March 22nd, 2022. In the trial court's judgment entry, Judge Larson states, because the plaintiff did not provide a record for this court to review the magistrate's decision, this court adopts the magistrate's decision with regard to the attempted purchase of the vehicles, in plural. There are 2 problems with this statement by Judge Larson. First, I did provide the trial court with a timely filed affidavit of the evidence under Civil Rule 53D3D3. And
When did you provide that affidavit? When you filed the objection or sometime before the 24th? When did that happen? Your transcript of, you're saying you filed an affidavit, a transcript saying this is what happened at the hearing. Was that filed with your objection? Was that filed after you couldn't get the CD? I was kind of curious when you gave that to the court.
after the magistrate's decision,
Okay.
before the judge got to look at it.
Okay.
And he used that affidavit to sustain my objection to the magistrate's failure to rule on my claim that the Balls stole my BMX bike and bike rack, which were worth approximately $1,000. Second, Judge Larson uses the word vehicles in the plural here when adopting the magistrate's decision. But when you read that decision, the magistrate only mentions one vehicle, the BMW. He never mentions the Pontiac G8. So Judge Larson has adopted here the magistrate's decision on the Pontiac G8 when the magistrate himself never made any findings or decision on the Pontiac G8. If this isn't judicial incompetence at its highest level, I don't know what is. Based on these missing items as shown in my brief and in the record, my total is $6,057.71 in damages. The maximum allowed for a small claims lawsuit, however, is $6,000. The judgment entry should therefore order the Balls to pay me $6,000 plus court costs. Instead, it orders them to pay me $2,382.83 plus court costs. This is unacceptable. Both the magistrate and Judge Larson clearly lost their ways here and butchered this lawsuit, thereby creating a manifest miscarriage of justice by their own incompetence at law and their lack of attention to details. I ask this court put right what Judge Larson has made wrong. I ask this court to reverse Judge Larson's judgment remand the matter to the trial court to correct these errors of fact and law in my case. Thank you for this court's time.
Let me just ask you a question so I can make sure I understand your argument. So you're saying that because of your indigency, the transcript was unavailable to you, and as a result, the affidavit that you submitted in and of itself under Civil Rule 53 was sufficient?
Yes, ma'am.
Thank you. Well, we will take the matter under advisement, and we will let you know of our opinion, our decision, by sending you a written opinion. And it'll be sent to all the parties by the clerk of courts, and we also will release our opinion on the Supreme Court website, so you can check there too as well. Okay,
Thank you.
thank you.